Let us discuss the 5 steps in the divorce procedure. Often, when you have some understanding of the various steps and stages involved in the divorce process, it can help to reduce the fear of the unknown and prepare you for the way forward. Let us start with the preparation and the first consultation. Your divorce attorney will obtain a complete overview of the case by asking you many questions. We will also require specific documentation from you. You must answer all the questions asked with complete honesty and add as many details as possible. After the consultation, you will leave and we will work on the first draft of the legal documents. This draft will be shown to you to read and check, and it is only when you agree with the contents of the documents that we will sign them off and have them served. The next step is the filing of pleadings. Once the divorce summons has been signed, they are delivered first to the applicable court to obtain a case number and then to the sheriff concerned. This is decided upon according to the jurisdictional area applicable. These documents are known as the combined summons and the particulars of claim. They are generally served upon personally on your spouse, who then has 10 to 20 working days to respond. Now let us talk about settlement. Settlement can take place at any stage of the divorce procedure, meaning it could happen during the preparation phase or even just before or during the trial. However, the standard and most proper place for settlement discussions would be after the filing of the pleadings and after the discovery process. We usually organize what we call a roundtable discussion so that both sets of divorce lawyers and both spouses can be present around the same table to discuss the details of different settlement options. When this is successful, it means that a settlement has been reached to which both spouses agree and consider fair and just. After this, the divorce lawyer on record will draft a document called a settlement agreement, which sets out in writing all the details that have been discussed and agreed upon by both spouses. This is then signed by both spouses in the presence of the witnesses concerned. To reach a settlement at this point will make things a lot easier and less expensive. If settlement failed, we continue with the process of discovery. We ask our client to bring with them specific documents, a lot of documents, to amass as much information as possible. The client will be asked for bank and credit card statements, property documents, emails, pension data, and many other documents. The lawyer of your spouse will do the same thing. The lawyers then share their collected information so that they have in their possession not only the information about their own client, but also the information about their legal opponent's client. This helps the divorce lawyers understand the focus of their legal opponents and ensures that neither spouse hides anything to get an unfair advantage. The last step in the process is the actual trial. Most matters do not get to this stage, as settlement usually takes place at some point before trial. However, in the unlikely event that a case proceeds to trial, the length of the trial, i.e. how many days it is expected to be in court, is usually decided by the amount of matters under dispute.